So I think mature minors is an issue that Canada needs to be taking seriously, that it's something that we need to deal with eventually, both legally and ethically, that they should be able to make their own decisions.
Do you know if there's any decisions that are sort of excluded?
Yes, a major one is medical assistance in dying.
But do you think that the sort of a constitutional challenge would be on sort of firm ground, maybe at least from an ethical standpoint?
If we let people refuse treatment that leads to their death, then the difference between a refusal for it and making a request for it is not ethically significant.
We talked a little bit about slippery slopes. We may as well extend this to its extremes. So fascinating conversation today. We're going to be talking about MAiD and mature minors. So currently in Canada, you have to be at least 18 years of age in order to be eligible for MAiD. That's one of the eligibility criteria. But there are conversations about whether we should be allowing people under the age of 18 who are capable of making that decision to access MAiD, so a mature minor. So to help with this conversation, we're going to be talking with Eric Mathison. He is a clinical ethicist. So Eric, thank you. Welcome to this conversation. So I will have just mentioned you in the introduction, but did you want to take a second to introduce yourself, let us know what your academic and professional interests are, and anything that you're working on?
My name is Eric Mathison. I'm a philosophy professor at the University of Toronto Scarborough, and I work in bioethics.
So just want to thank you for taking some time to chat with me. We're going to be talking about medical assistance in dying, specifically with reference to mature minors, and it's something that is being considered at least on a very low level of conversations in our federal government. And I just thought it would be interesting to go through that from your ethical perspective. But I think maybe we could start with just what is presumed capacity, and is that tied to age in any way? Maybe just start off with a base of trying to understand what this concept of capacity in mature minors is.
Sure. Yeah. So in Canada, both ethics and the law are aligned that adults are presumed to have capacity. So that means that if somebody goes in, has an interaction with a healthcare provider, goes in for any kind of appointment or checkup or anything, that there's a presumption that the patient has capacity, unless the provider has some reason to believe that that's not true, in which case they have to the provider have to demonstrate that the patient lacks capacity.
Mm. And is that tied to age in any way, or are those under 18 presumed to have that, or is there some different standard to sort of determining that?
It's different province to province. So in Ontario, where I am, there is no age. So actually, everybody is presumed to have capacity, even like young children and babies, but they would be immediately disqualified from having capacity. In Alberta, which is my home province, it's the reverse. Anyone who's younger than 18 is presumed to lack capacity, but they can demonstrate it. So they have a right to demonstrate capacity. Okay. And in BC, I think that it's also that it's not presumed, but once again that the patient can demonstrate it.
Okay. And does the burden of determining capacity, does that change based on the risk or severity of possible outcomes?
Many people in ethics think that there's a higher bar for as the risk increases, that at least that there should be more diligence, or that more kind of looking into it to figure out, given that the stakes are much higher. And I think that would follow anyway, just given the kind of severity of it and the kind of types of interactions that go on.
Okay, so it's more of a just a practical sort of application of the outcome is severe, so the practitioners would put more effort into making sure that the person was capable. Would that be an accurate summation of that?
Yeah, definitely.
Yeah. Okay. All right. So then there's this idea of a mature minor doctrine. Can you sort of explain what that is and how that aligns with broader principles of informed consent and patient autonomy?
Sure. So a mature minor is a minor, so somebody who's younger than the age of majority, but who has full decision-making capacity, or who has capacity to make the particular medical decision that they're facing. So this has been recognized by the Supreme Court of Canada, and jurisdictions across Canada recognize that it's a doctrine. So the idea is that a minor, somebody who's 16, 17, or whatever age, can still have full decision-making capacity and should be permitted to make their own medical decisions.
Do you know if there's any decisions that are sort of excluded from a mature minor that has been deemed capable of making?
Yes, a major
Okay.
one is medical assistance in dying.
Oh,
So
yeah. Other
specifically,
than that, I guess.
oh, okay.
Yeah. Yeah.
No,
We'll get
I actually I don't know if there are any other ones besides that. I think that in Quebec that there are certain ones if it's not medically necessary, like cosmetic procedures, that
there.
there are more. You need like you need a kind of it's not exactly a substitute decision maker, but you need like a kind of a parent or somebody else involved. But other than that, I don't think there are specific ones.
Okay. When it comes to determining someone as being capable as a mature minor, is that process or the principles any different than with an adult?
So I think the underlying idea that the patient has to understand what they're consenting to, what the risks and benefits are of the procedure, what might happen if they refuse that treatment, and so on. That the concept of capacity is the same regardless of the age, but it's definitely a point of discussion among pediatricians, among other providers who work with minors that the kind of figuring out whether an individual has capacity, whether a minor has capacity, that process might look different. And given that we think of capacity as it's not purely a binary. It's something that that
Hmm.
comes into existence. We get more of as we mature, and that we can also lose. That the kind of the measurement of it that it might be different among minors.
Okay. But so practitioners now, obviously excluding MAiDs, that's not a thing right now. They're quite capable of making these determinations with time and effort and bringing in other expertise. That doesn't seem to be an issue in making that determination. Would that be true?
Yeah, that's true that there are, that is definitely part of the job description. I think there are worries among providers about, and across the board, not specifically for MAiD, about the kind of amount of training that they get to do those
Mm.
assessments and just how complex it is.
Yeah.
So I've heard from pediatricians that there just needs to be kind of more support for that. But yeah, that's not specific to MAiD. That's something just for across the board.
In general, yeah. So when it comes to the concept of mature minors, so it's well established in medical practice in Canada. But how is that then applied to the life and death decisions, such as refusing, say, a life sustaining medical treatment compared to say less serious medical choices?
So the concept is that if somebody has decision-making capacity, then both legally and ethically, that they should be able to make their own decisions, including for end-of-life decisions. So, unfortunately, that there are minors who in Canada every year who are in end-of-life situations for cancer or other diseases. And they, have to make decisions. Once again, there's a Supreme Court decision, ACV Manitoba, and there are, decisions or kind of circumstances that occur in hospitals across Canada. And the idea is that if they have capacity, if the minor is able to make his or her own decisions, that they should be allowed to do so.
Should be allowed. Okay. Are there any circumstances where a mature minor's decision could be overruled by parents, guardians, or anyone from the medical community?
I think that because the threshold is higher, I think that there's not as much kind of latitude that we would give to an adult. And I don't know this is so much about kind of capacity, but I think that if a minor were kind of making a more unorthodox medical decision or refusing treatment that otherwise seemed kind of that seemed necessary, but maybe they weren't able to justify it. I think an adult, like a 30 or 40-year-old, would get more of a pass on that they have the right to refuse. But I think a minor, it would probably be scrutinized more, and maybe even then kind of overridden. It's not that the parents like can just step in and override it, but it might be
Hmm.
more likely to go to court or to in some other way kind of be challenged.
Right, I understand. Yeah. So then, are there any changes to the mature minor doctrine, or how we handle these sort of situations that you might advocate for?
I think that it's an issue that across Canada, different jurisdictions have different different systems. That that there are some provinces that have an age that select specify an age below which you just cannot be deemed to be capable. That I think is a mistake. But I think just that there's so much variation is I think itself a problem. That it's very strange kind of thinking that a person could just move provinces and all of a sudden be presumed to be capable and be able to make decisions that across the border she wasn't able to make.
Right.
So I think that addressing that is is something that's worth pursuing.
Okay, yeah, it's interesting. We'll talk about MAiD and mature minors in a second, but with MAiD being federally legislated, any sort of changes in mature minor access to it might precipitate a more federal sort of response to mature minors in general. I wonder.
Yeah. I think that's an interesting question about how it would be specified. Like the federal law might say MAiD for mature minors is permissible, but maybe they don't specify what mature minor is, and
What I mean, that's true. Yeah.
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 So, but that we'll wait and see.
Yeah. Yeah. Good point. Okay. Are there any sort of concepts about mature minors in general, mature minor doctrine that sort of we haven't talked about or I've missed anything? Just the major sort of highlights.
Yeah, I will just say that that there's a debate about whether we should have the concept of mature minors. That there's kind of two ends of the spectrum, and on one of the spectrum is the view that a person should be assessed for capacity and they should be allowed to make their own decisions regardless of their age.
Right.
And the kind of brain maturation and development, that's not something that happens at exactly the same point for everybody. So that it should just be assessed on a case by case basis. But there are bioethicists and others who argue that that it makes sense to have an age for medical decisions, and partly that's based on kind of brain science. Partly that's based on just the practicalities of assessing everybody. So there's a debate in itself about whether we should recognize mature minors, but I think that the majority of bioethicists agree that that capacity itself is not saying that it's something you get when you turn 18 is not really ethically justifiable.
Yeah, there's not a switch that happens on a particular day. Yeah.
Yeah.
Right. Okay. So I'd like to move on to sort of questions about mature minors and MAiD specifically, if that's okay. And I maybe start with so MAiD was decided in the Canadian courts. There was a lot of focus on the grievous and irremediable medical conditions, intolerable suffering, but the courts didn't really say anything about an age limit. So they didn't say only people over 18 or adults. They sort of said a competent adult person. And now that's, as you said, that's generally considered to be 18, sometimes 19, depending on what jurisdiction you're in. What would be the ethical perspective on such an age requirement? You've sort of talked about that, given that we do allow mature minors to make other life and death decisions.
Yeah. So just to on Carter, the legal case, and today is actually the 10-year anniversary of it that we're recording this.
Right. Yeah.
So as you mentioned, that they talk about competent adults, but that is they're clear that that is because the people involved in that decision were well over the age of 18. So in the decision, the Supreme Court is clear that they're commenting on kind of that set of cases where it's grievous and irremediable, and they're clear that they're not excluding other sorts of instances. So it's definitely still possible that mature minors could be compatible with the Carter decision. So the ethical case for it is that there are minors who get grievous and irremediable medical conditions like cancer, which is the most common condition that leads to a MAiD request, and that both. They have suffering, they meet that condition, and because they're a mature minor, they also have the autonomy to make their other medical decisions. In Carter, the Supreme Court said that there's a consistency argument that if we let people withdraw life-sustaining treatment, if they can switch to palliative or comfort care, if they can disconnect ventilators and other sorts of things, then they should also be allowed to make decisions to hasten their own death through an assisted death. And so the argument for mature minors is that there aren't many cases where a minor would qualify. but there are some, and it's arbitrary to say that you have to wait until you're 18. And so if there were somebody who were 17 or 16, for instance, and that person is deemed to be fully capable, then it's unethical, I think, to prevent that person from accessing MAiD, to tell them that you have to wait until your 18th birthday and then you can have it, whereas before that you're not allowed.
Right. So then do you think, and this might be dipping into more the legal side, but do you think that there's sort of a constitutional challenge would be on sort of firm ground, maybe at least from an ethical standpoint?
From an ethical standpoint, yes. I think that the reason it hasn't happened is that there aren't that many of these cases. Finding somebody who wants to do it is difficult. But yeah, I do think that the Supreme Court in Carter, that they were already kind of making this big change, and so they didn't have to consider it for minors, and so that's why they didn't. But there's definitely nothing in that decision that excludes it, and also just looking at the kind of to be consistent with other decisions that they've made, I wouldn't think that they would rule it out.
Okay, so there doesn't seem to be any sort of meaningful, at least ethical difference between allowing a mature minor to refuse life-sustaining treatment and allowing a request for MAiD. There doesn't seem to be any reason why that shouldn't be allowed. Is that right?
That's right. I think that there are people who think they shouldn't be allowed to refuse life-sustaining treatment, that they don't have the life experience, or that they don't have the that they're not, they might make a spontaneous decision or something like that, or other sorts of slippery slope arguments that people make. But I think the consistency argument, whether it's a minor or not, is that if we let people refuse treatment that leads to their death, then the difference between a refusal for it and making a request for it is not ethically significant.
Right. Yeah, for allowing one, how can we justify not allowing the other? Yeah. So I can imagine, I can't jump on them here. I can imagine a single case where a mature minor has a terminal illness, severe suffering, a short prognosis, where most people could understand that desire not to continue that suffering and end their life through an assisted death. And if we can imagine just one case, then aren't we just sort of then arguing about sort of the specifics of allowing that, the degrees, the criteria, or is there some sort of broader concern that while we recognize that one person can do that, there is some potential harm to sort of society that outweighs that right?
I think people worry about that. And often when there's kind of concerns about this or slippery slope type arguments, it is thinking in these broad terms that if we open up this, then who knows where it's going to lead us. So certainly concerns about vulnerable people and minors are certainly could be considered in that group. That there might be differences in kind that minors might be, they're more persuadable. Their parents might try to influence them, or their other members of the community, and so they might not be able to make kind of, even though they're capable of making a decision, that it might be difficult for the MAiD assessors to distinguish that from somebody who's whether it's like truly kind of an authentic decision that they're making, and that kind of writ large could. I think that's the type of concern that people have in mind.
Yeah. I mean, I don't think that's terribly different from what they're having to do now when it comes to determining if there's undue influence or if this is a true decision that they're making. And the practice that I know they do now is when there is a concern that the process doesn't move forward and they're legally bound not to do that. I guess it's maybe just the difficulty of determining that increases with any complex case, whether that's mature minors, mental illness, or we think of it, you list any number of specifics.
Yeah, I don't think that it actually changes in kind. It might. I'm not even sure if it actually changes in degree. Like there are already concerns, and in my, I also work as a clinical ethicist, and in that work, I get consults about kind of influence, undue influence, or coercion, and helping providers kind of puzzle through that. But this is something that already happens in the healthcare system in lots of different situations. So it's not a new problem. MAiD it's not a new problem with MAiD, and it wouldn't be a new problem with mature minors. So I think it's a concern, and it's certainly something that we need to be aware of. But as you say, that the assessment process is, that's a major thing that they're looking for is there any concern that the person is not deciding this authentically?
Yeah.
And just to kind of comment on my own point about family influence, that I would say of the clinical consults I've got where there's been a concern about family influence, like 95% of those cases have been the family trying to influence the patient to stay alive longer.
Yeah.
It's much, much rarer
Much
in my
common. Yeah.
experience. People I think often worry about the other way, that they'll try to pressure the person into dying. But we actually, as well, from the MAiD data, the federal data that was released in December, that now that's actually tracked, and there were 30 cases of people who changed their mind to not get MAiD because of family influence. So we know that happens in that direction, but I think that kind of influence, like the people who object to MAiD don't worry about those cases as much.
Yeah, I would completely agree with that. I've had that experience myself. I've seen that. I've seen families that have been able to convince someone not to go forward with it. Is there a concern with someone saying, I'm not going to go forward with this because my family doesn't want me to?
I don't think that on its own is a problem. When I get consults about this, they are concerned about that kind of on its own. But I think that it is like being in relationships, having a family, that we influence each other, and being open to hearing what your loved ones think and their views. So I think changing one's mind because of what your family has told you, I don't think that on its own is a problem. There are problems if it can cross over into being problematic. But just having family involvement is that on its own is no reason to think that something kind of ethically untoward has happened.
Yeah, yeah. Perfect. Thank you. You mentioned the slippery slope argument. So that's the idea that once we allow something, in this case made for maybe mature minors, it's going to inevitably just expand to include all these other groups that were never intended. So you can think of the original law got expanded. Now, I don't agree with this argument, but it got expanded to people with no reasonably foreseeable natural death, folks with a mental illness as a sole underlying medical condition. Now we're talking here about possibly what's the impact of someone as a mature minor getting access. But I sort of look at it a bit differently in that, and I try to explain this to people, and maybe you can tell me if I'm making a good case here, is that once we allow this for a general group, it's up to other people to say why certain groups should be excluded. So why shouldn't someone with a mental illness be allowed to have access to this same thing that every other capable adult has? Why can't a mature minor have access to this? It's up to the people who think they shouldn't to explain why, once we've sort of established that this is something that's generally available within the criteria.
Yeah, I think that I agree. I think that the people who make that argument are kind of making a kind of a consequential, to use some philosophy jargon. They're kind of like they're saying that the downside is that other people are going to be kind of caught up in it. So this is something that's commonly made by people who are objecting on disability grounds.
Right.
The Track 2 MAiD kind of opens up and allows MAiD for in some cases when people have a disability, and so then the worry is that's going to coerce or pressure people with disabilities into getting MAiD. But I think that's a mistake for thinking that. I think it's a mistake to treat a group of people, a class of people like people with disabilities, as being all so vulnerable that they can't make their own decisions. I think that's kind of an unjustified form of paternalism. And as with minors, I think that we can say, sure, we need to worry about capacity, we need to worry about all of those things, but at the end of the day, the individual, that patient, should have the right to demonstrate that they meet those criteria, and then just excluding them to save these kind of other hypothetical people, I don't think is justified.
Yeah. Yeah. So then, if we were to, if Canada was to allow mature minors to have access to MAiD, would you argue for or against having additional safeguards that aren't required for those over 18 right now?
Yeah, I don't think that other safeguards would be necessary. I think that I'm pragmatic enough that if that was required, then sure, better to have it.
Mhm.
So I think that there are some that, given how few cases there would be, so the kind of estimates comparing Belgium and the Netherlands, which both allow MAiD for mature minors, it would be something probably around 20 Canadians a year.
Mhm.
Would qualify, or would end up having it. So that's not very many cases. So if there was a requirement, like there had to be an additional assessment, or a psychiatrist to do the capacity assessment, or so on, that I don't think that that would be. Uh, um, I would be fine with that if that's what was required. But for all of these things, every safeguard that we put up is also an obstacle that can prevent people from timely
Mhm.
access.
Yeah.
And if that minor, was kind of quote unquote unfortunate enough to be in a smaller town, or wasn't able to get to a bigger city where assessors are more available, then I think that those safeguards could very easily end up blocking them, and the result being a lot more suffering for them. So
Mhm.
so I don't think safeguards are kind of zero cost. I think that any safeguard that we put up can end up leading to worse results, and getting in the way of autonomy, and also contributing to suffering.
Yeah, it makes me think of a few different things. The original legislation that came out that had the 10-day waiting period that is no longer in place was just found to create 10 days of suffering
Yeah.
with no actual like positive outcome. Or even thinking about some of the proposed legislation in the UK right now that includes going in front of some sort of legal panel to see if you're eligible. That just seems to be such a such an onerous process to effectively make it just not accessible to anyone, which is problematic. So I
Yeah.
see your point of adding those sort of things to a subset like a mature minors. While might make sense and people might argue for it, if it goes too far, it can actually cause more harm than is intended.
Yeah, and I think we need like actual evidence that there is a serious enough risk
Hmm.
in order to justify the safeguard. That like by analogy, that abortion in Canada, if a woman wanted an abortion, she would have to go before a hospital abortion committee that had to have at least three doctors, and
Right.
they had to assess it, and so on. And of course, the result was that abortions which were much harder to get. Many hospitals didn't have a committee, or wouldn't approve them, and so on. And so these are all obstacles to people kind of being able to decide for themselves and making their own choices about their lives.
Yeah. So we talked a little bit about slippery slopes. We may as well extend this to its extreme. So some might argue that permitting MAiD for mature minors is going to lead to further expansions that erode safeguards such as euthanasia for newborns in exceptional circumstances. How do you approach concern or question like that?
I think that any slippery slope argument is, one, it's making a prediction that if we do X, then Y is necessarily going to occur. And the problem with slippery slope arguments is that they involve these kind of big predictions that often turn out to be false. So we should be suspicious of them. But the other thing is that the slippery slope suggests that that things are going to get ethically worse. It's going to lead us to something that's ethically unjustified. And so in order to assess them, we look at the prediction, and then also look at, well, would it actually be ethically unjustified? And I think that in the case of newborns, the paradigm kind of switches, because now we're not talking about extending autonomy. Now we're talking about using a best interest standard. Obviously, the newborn can't consent, and so thinking about consent just isn't the right framework to use anymore. Are there situations where newborns are born and have grievous and irremediable medical conditions that will prevent them from ever living a life of a high enough quality? And the answer is yes. Unfortunately, thankfully these cases are less and less common with medical technology, but they do happen. Complications during birth, for instance, can cause these to happen, and so there are babies who are born that might only live a few months, or sometimes only a few weeks. And what happens now is the withdrawal of nutrition and hydration, and that can be you know they're monitored, they're given pain relief, and so on. But the idea that we should draw that process out when the goal of withdrawing nutrition and hydration is to hasten the baby's death, where we see that death would be better for it, then there's really no ethical argument, I think, that prevents us from allowing it from happening in that case. So that I just don't think it's ethically justified to insist that even when the parents are okay with it and the medical team is okay with it, to say no, like we simply can't allow this child to die in this way, where it would be better for the baby, it would be better for the parents, and better for the medical team.
Is there any validity to the argument, or the idea that even though we can make an ethical argument for why one is not terribly different than the other, the withholding nutrition or actively saying we are going to end this person's life, that we just don't want to live in a society that does that? Or is that just another version of I don't feel good about this and I don't want to actually think through the actual implications of this position that I'm taking?
So I think there are things where that might be the reason, like we don't want to live in that kind of society. But I want to know what the basis for that is. Because of course people have made that argument for, I don't want to live in a society that allows gay marriage, or I don't want to live in a society that allows people of different races to be together. So it's not to say that that those are all analogous to being against MAiD for newborns, but I think that on its own is just like it is very difficult to think about, and just because it's such a tragedy no matter what. But just being squeamish about that, that I think that my kind of like philosophical view is that intuitions about ethics can be helpful. They can point us in the right direction, but they can also mislead us. And so that squeamishness might not actually be pointing to ethical truth. It might actually be kind of misfiring. And so once we look at it more closely, I think that there's just not really a lot that we can say to back up that claim that I just don't want to live in that kind of society.
Right. Okay. Yeah. So our ethical intuitions can guide us, but without an examination of what they're actually saying, it's wouldn't be right to follow those through. It's really important to actually think about kind of what that's saying.
And that's actually a point, I think that applies for MAiD a bunch, that that many of the objections that I find to MAiD, that they start from the recognition that there is kind of some aspect that is that is troublesome. So I think wait times for healthcare, or unaffordable housing in Canada, or disability support, or whatever it is, that those are all real problems, and those are motivating people. But I think it's like misleading them. It's a red herring to focus on MAiD in those cases. So with MAiD for newborns, I think that it is just the squeamishness of it, that it is just such a difficult issue. But I think that ethically, I don't think that there's. I think that the arguments in favor of allowing it are stronger.
So what's your best argument for allowing MAiD for mature minors?
I think that the best argument is that we should treat individuals as individuals, and that some minors, some teenagers are capable of making their own medical decisions, that they have the ability to understand the situation that they're in. Unfortunately, many of the people who would qualify for MAiD, I mean, they're ones who are likely to know the healthcare system very well, because they're ones who have probably been in the healthcare system, going to the hospital and so on for quite a long time. So just saying, as a group, that they're unable to make responsible decisions, or unable to understand their own information about their decisions, I think is making a judgment about them that is empirically false, but I think is also unethical. So we should allow MAiD for mature minors for the same reason that we allow it for adults, which is that people should be allowed to make their own medical decisions, to just make important decisions about their life, including about their own deaths, if they meet the criteria.
So then, can you think of any even remotely convincing arguments to yourself about why we shouldn't allow it?
So I think that the most difficult aspect about mature minors is capacity. So I think capacity is difficult to assess. There is no kind of it's not like something out in the world where where we have a test that says for sure whether somebody has it or not. It's a construct that we have that is important, but it's not like doing a test for like pregnancy where we can we know that it's like a thing out in the world. And so capacity, we know from studies that there's a lot of noise that you can give to capacity assessors the same kind of case, and they might come to different answers, so people disagree. And then as we add in other factors like mental illness and so on, that can lead to more disagreement. So I think that's an issue. That's an issue across for medicine. I think that healthcare overall is not kind of taking that. It's such a foundational thing, and I think that there's kind of a lot more work that needs to be done. But again, I don't think that that's an argument that would justify banning MAiD, but MAiD for mature minors. But I do think that we need to make sure that we're getting it right. That it's tough to assess. People can disagree. It takes special training for minors. So we need to make sure that all of those pieces are in place.
Mm-hmm. Yeah. So it definitely, this is a complex topic. I mean, MAiD in general is complex. And when we add in things like mature minors, it just gets much more difficult. So I think it's important that we're having these conversations and people are talking about it and thinking about it. So I definitely want to thank you for taking the time to do that. I do have one other sort of question though.
Sure.
So for up until about a year ago, I've done a lot of teaching to healthcare professionals about MAiD, and up until a year ago, I always said that MAiD was a right in Canada, and I have you to thank me I've you to thank for correcting me on that. And I don't know if I've ever formally acknowledged that anywhere. So is MAiD a right in Canada?
Well, I have Jocelyn Downey to thank
Oh, okay.
the legal
Pass it on.
professor. So I mean, I guess it depends what somebody means, to say the philosopher thing. It depends what you mean by right. But no, there's no legal right to MAiD in Canada. There's no legal right to healthcare in Canada. That's not something that's kind of enshrined. So there's nowhere in the charter or in any law that says that you have a right to medical assistance in dying. I think that if you think of the law as being the law specifies what we can't do. It's the list of restrictions, and then in that sense it makes it a permission. But I don't think that there's a right to MAiD in Canada.
All right. Thank you for that. Is there anything that we've missed at all about MAiD mature minors that you think is important?
No, I do think that there are so many different issues around MAiD. We're discussing mental illness right now in Canada. There's stuff about structural things, forced transfers, and so on, as well as the stuff that's already legal. Still debates about Track 2 and even Track 1. So I think mature minors is an issue that Canada needs to be taking seriously to consider it, that it's something that we need to deal with eventually. But at the same time, there's a lot of other stuff that we also need to be dealing with. So in terms of priority, we also have advanced requests and a number of other things. So I think that the approach of considering it one by one, that's the right way to do it. It's important to have these discussions to make sure that we're getting it right. But at the end of the day, I also think that all the time that we are taking, all of these delays can result in real harm to people. So just delay for the sake of it is not warranted. We need to be careful about that.
Agreed. All right. I know where I found you. Where can people find you, see the work that you're doing? Anything you want to promote while you're here?
Sure. Yeah, I have a Substack newsletter called Value Judgments, and I mainly write about medical assistance in dying, but I write about other bioethics issues. And you can also follow me. I have a YouTube channel where I talk about bioethics issues on there. So also at Value Judgments. So please check out either of those.
Perfect. Yeah, I'll add some links into the description of this one. All right. Thank you very much.
Thanks, Paul.